Welcome. Can I just remind members again that to switch off phones and Blackberries, as they will interfere with the recording equipment. I have no apologies that I received. Of members aware of any apologies?
Chair, I will have to leave about 4, so that's apologies if we're not finished before.
Thank you. Under Chairperson's business, can I remind members that the committee debate on the work that we did on learning disabilities and health inequalities is scheduled for Monday, the 3rd of February, this Monday. So I want to also advise members that if they want to deal with the legislative consent motion on standardised tobacco packaging, this is on agenda item 16 and it's in the tabled papers today. The Department has laid a legislative consent memorandum which contains the wording of the proposed motion on Friday. This is at page 44 of your tabled papers. There's also a letter from the Minister which was received yesterday, which is also on the tables on a separate sheet, just a single sheet here. The Minister is explaining that he has already laid the motion in the Business Office in order to allow it to be debated on Monday the 3rd of February, despite the committee not having formally approved it. The Minister has explained that this is because of the tight timetable through Westminster and the House of Lords. The committee's role, therefore, is to decide if it's content with the proposed legislative consent motion. Members, just to refresh people's memories, had indicated at the previous meeting that given the importance of this particular issue that we were indeed content in principle, but I would need to put that formally, the question formally to the committee. So can I ask if members want to raise any issues first and foremost? Happy enough to proceed? Okay. Can I ask, therefore, is the committee content with the proposed legislative consent motion?
Content.
Thank you. The next step, then, members, is for the committee to publish a short report on its consideration of the proposed motion. A draft report is at page 54 of the table papers. Which is straightforward in terms of the process. So can I ask, would the committee be content with that draft report?
Content.
The committee's report will be emailed out to all members at the Assembly, members of the Assembly tomorrow morning, and the debate on the motion, as I said, is scheduled for Monday, the 3rd of February. Can I just advise members also at this point that in terms of procedure, I think we should point out that the normal procedures and policies have not been adhered to here by the Department. The normal procedure is to allow the committee 15 days to consider a legislative consent memorandum before it produces a report. But in this instance, we've had only 3 days to produce the report in order that it's produced before the plenary debate. This is not the way I think that the committee would like things to be done, and we would hope that in future legislative consent motions will follow the established time.
Madam Chair, that should be highlighted to the Department.
Yes, I think it will be coming from this meeting. I think there were members, as we reflect on an urgency in relation to timetables that were outside of our control, and we had actually indicated that we were content to proceed. But certainly, you're right, in future we want to follow the established time. Can I move members on to the draft minutes of the meeting on the 22nd of January, which are at page 8? Can I ask, are members therefore content with the minutes?
Great.
Thank you. And item 4 is the evidence session on the summary of responses to the public consultation on the termination of pregnancy guidance. I want to refer members to the Department's summary of consultation responses, which is currently available on their website, and it's at page 13 of your papers. There is a briefing paper from the Department at page 3 of your tabled papers, which again was only received yesterday. Guidance, which went out for consultation in April, is at page 12 of the tabled papers for members' reference. Can I just remind people at this point to maybe move the tablets slightly, because I think they're interfering with the recording, myself included. Okay, folks, you're very welcome. We have Eilish McDaniel, Director of Family and Children's Policy at the Department, Dr Margaret Boyle, Senior Medical Officer in the Department, Mr Alistair McInnes, who is Social Services Policy Group in the Department, and Zoe Borland, Nursing Officer at the Department. You're all very welcome. You're fairly familiar with the procedure, so we'll just hand it over to yourselves to make a 10-minute presentation, and then we'll open it up to questions and comments.
Okay, thank you, Madam Chair. Thank you for the opportunity to provide information to members of the committee this evening. Can I begin by offering my apology for getting the paper to you that you requested very late in the day, and I hope that we'll be able to answer any questions that you may have as fully as possible during this session. When we last appeared before the committee on the subject of termination of pregnancy, we were still assessing and analysing the responses. Since then, we've provided you with a summary of the consultation responses, and that summary is also available online for members of the public. It's worth reminding the committee that the Department received 86 responses to the consultation from a wide range of interested groups. Although the draft was heavily criticised, the consultation was successful in the sense that consultees responded with great clarity and provided us with an enormous amount of very helpful information. The document was criticised for being too pro-choice, and it was criticised for being too pro-life. This is a subject which generates very different views, polar opposite views in fact. It will not satisfy those who seek to introduce the 1967 Act into Northern Ireland, and it will not satisfy those who think that abortion is wrong in every circumstance. Abortion in Northern Ireland is governed by the criminal law. The formulation of the law and the case law that is developed means that it's not possible to give absolute clarity in a guidance document whether any given medical procedure is legal. In Northern Ireland, abortion is lawful in very limited circumstances. The nature of those circumstances is such that every case must be evaluated by a health professional based on his or her clinical judgment. An enormous amount of responsibility is put in the hands of health professionals as they strive to produce the best outcomes for women within the law. It's important that the guidance we produce assists health professionals to make decisions within the confines of the law. They are the people at the front line, dealing with pregnant women who, for whatever reason, are facing a choice that may be incredibly painful for them and for their families. It's equally important that the guidance empowers professionals to act decisively within the law based on the clinical circumstances that they face. We want to ensure that women, no matter where they're from in Northern Ireland, are able to access services which meet their clinical needs. The difficult circumstances around this subject became evident in a number of media stories which ran last year and which the committee will be familiar with, and which serve to personalise and to put human faces and voices to the subject. We want to produce guidance which is consistently applied to ensure that the health and social care system provides comprehensive assessment, effective health care where it is required, and information to help pregnant women in very difficult and often traumatic circumstances. Before I discuss the detail of the issues that were raised and how the Department intends to address them, it's worth repeating that the guidance cannot change the law. The Department of Justice is responsible for the criminal law, and I now understand that the Justice Minister intends to consult on the issue of lethal fetal abnormality. While health officials have engaged with the Department of Justice on the matter of potential changes to the law, we cannot answer questions about their proposals. These are matters for the Minister of Justice or his officials to comment on when their proposals are finally firmed up. When we spoke last to the committee, we explained that there were that we had broken the responses down into 7 broad categories. And with your agreement, I intend to take members through each issue in turn and indicate how we intend to deal with the issue in the revised guidance. The first category was the law on termination of pregnancy. Although the consultation made clear that the guidance could not change the law and that there were no proposals to change the law, a number of responses suggested that it should be changed. While we will update the guidance to reflect the current understanding of the legal position and will acknowledge the DOJ proposals, we do not intend to address the issue of legislative change in the revised guidance. The document was much criticised for its perceived punitive tone and threatening language, which was described as having a chilling effect on health professionals. The purpose of the guidance is to clarify the law for health professionals and to ensure that it is understood that a failure to comply with the law on abortion is a criminal offence. In other words, the penalty for non-compliance is severe, punishable by life imprisonment, in fact. Nevertheless, as a health department, we are clear that health professionals must act at all times in the best interests of their patients and respond effectively to their medical needs. We want health professionals to treat their patients confidently, in good faith, and on the basis of a professional assessment of a woman's individual circumstances. As the guidance is aimed primarily at health professionals, we will seek to use medical terminology throughout the document. The second broad category of responses related to the mental health grounds for a termination. There were mixed views on the proposal that a consultant psychiatrist should examine a woman who could be considered for a termination on mental health grounds. We've considered this matter again and acknowledged that health professionals regularly make assessments of mental health in many areas of practice, and that while a psychiatrist can make an assessment on the state of a woman's mental health at a moment in time, he or she is unlikely to be able to predict the long-term impact of mental health problems resulting from a pregnancy. Furthermore, GMC guidance stresses the need for doctors to work within their professional capacity and to seek specialist opinion when it is necessary. And finally, we accept that health professionals who know it is probably a health professional who knows the woman's history and prognosis may not be a consultant psychiatrist. Taking all of these factors into account, we're giving consideration to whether we can achieve a less prescriptive approach to who can assess a woman's mental health. We will maintain the advice that 2 doctors should be involved in the assessment and management of the woman, and advise that doctors should seek the most appropriate specialist help in any particular case, in line with GMC guidance that they should work within their competence at all times. The consultation highlighted the issue of lethal fetal abnormality. We have received legal advice that confirmed that if the life or long-term physical or mental health of a woman are not threatened, a pregnancy involving a lethal fetal abnormality is not a ground for a termination in Northern Ireland. Minister Ford has indicated that he will consider this issue, and we will pay close attention to any action taken by the Department of Justice. The third category of response related to the recommendation in the guidance that any termination procedure should be certified by 2 doctors. While noting that the law in Northern Ireland does not require 2 doctors to certify, we were struck by comments from the 2 sides of the debate. Those who were pro-life perceived that the requirement protected the fetus, while those who were pro-choice saw it as a level of protection for the doctor. Both sides of the debate saw the benefit of the proposal, and on that basis we intend to retain the recommendation with a focus on the need to work within professional competence and capacity and seek specialist help in circumstances where it is actually necessary. Responses in the fourth category related to conscientious objection and the ability of a woman to seek a second opinion. The matter of conscientious objection is complex in the Northern Ireland context. Unlike other parts of the UK, there is no statutory right for staff in Northern Ireland to conscientiously object, although limited rights do exist in European human rights law. Despite the lack of statutory basis, there was broad agreement that staff should not be forced to participate in procedures to which they object on moral grounds. There was also broad agreement that in an emergency situation where the life of a woman is in immediate danger, the needs of the patient should override conscientious objection on moral grounds. We intend to reconsider the issue of conscientious objection to reflect the broad agreement that exists on the issue. We will need to consider the particular Northern Ireland context where, as the law stands, any termination will be by definition, every termination or any termination will by definition only take place where there is a threat to the life of the health of the woman. One particular issue that came to light during the consultation was a woman's right to clarity when she has been told that she cannot access a termination in Northern Ireland, that the decision has been made on medical and not moral grounds. GMC guidance already requires doctors to refer a woman they will not treat on moral grounds to a colleague who can. This is different from, and in addition to, the working assumption that a patient should normally have access to a second opinion if he or she disagrees with their doctor. Several consultees suggested that a woman should have a right to appeal clinical decisions and that there should be an appeals mechanism. And finally, on this subject, it was suggested that institutions should have a right to conscientiously object to carrying out terminations. And we do not believe this is possible in the context of the current law in Northern Ireland. The fifth category of responses relates to the provision of counselling services. This drew particular criticism and will need careful consideration. Two very distinct issues emerged. Firstly, some respondents queried what information can be provided to women on services available elsewhere that are not legal in Northern Ireland. And this includes the grey area, which was debated at length in the media at the end of last year. Secondly, some respondents sought clarification on the support women should receive before or after receiving a termination, whether carried out here or elsewhere, and whether it is legal to provide support in those circumstances in Northern Ireland. On information services, we are clear that it's not illegal to provide information on services available outside of Northern Ireland, nor is it illegal to travel overseas or to accompany someone when they travel overseas, even if it's known they are travelling to receive a termination that may not be legal in Northern Ireland. However, the courts in Northern Ireland have not ruled on whether it is lawful to advocate or promote, that is, to encourage or arrange for someone to have a termination. We will make it clear in revised guidance that this has not been tested in court, and that in the absence of current law on the subject, this remains a grey area, and that practitioners should be mindful of the fact. On counselling support for women, we will clarify that all women at any stage of the decision-making process should be offered appropriate counselling by the HSC. We will clarify that all women, regardless of whether they receive a termination in Northern Ireland or elsewhere, should be offered the full range of health and social care services it has been assessed that they need. The sixth major area that attracted comment in the consultation is the collection and sharing of information. The guidance proposed a new system to collect information, and there was broad agreement that as long as confidentiality is assured, additional information collection is acceptable. The intention is to collect data on the grounds for a procedure and where it took place. This appears to be relatively straightforward as far as HSC premises are concerned, but may require legislative change to access data from private clinics. The section of the guidance which dealt with the legal requirement for staff and others to report crime received much negative comment. As I mentioned earlier, the guidance does not change the law. However, we are aware that the prominence and tone given to the requirement of the criminal law may directly impact on patient confidentiality. There is also some evidence that it has impacted on trust within health teams, and several consultees suggested that women could be reluctant to seek help if they are concerned about their privacy or fear prosecution. We are considering how this is handled in the guidance, its prominence and its presentation, including the tone that is being used. It potentially impacts on patient confidentiality, and this was referred to in consultation responses. As a health department, our concern is to ensure that women receive the lawful treatment they need, whatever the circumstances. We will redraft the guidance to reflect the comments we received on the subject, and will also draw from GMC comments and guidance. The matter of abortifacient drugs being accessed through the internet was raised in this context particularly, and specifically mentioned by the committee and when we appeared before you last year. We will raise the prominence of this issue and seek to provide more detail on the legal position. Finally, the seventh major area raised concerned equality and human rights. This covered not only Section 75 issues, but also UK treaty obligations. The only Section 75 issue identified was the potential differential treatment of staff with religious views and their ability to conscientiously object. Many respondents mentioned that the law in Northern Ireland is discriminatory and suggested that because of the law in Northern Ireland, the UK is in breach of several treaty obligations. We do not intend to comment on the impact of the criminal law in Northern Ireland on treaty obligations. A number of European Court of Human Rights judgments were brought to our attention relating to legal certainty, the provision of information and the right to appeal. It's the Department's view that the guidance complies with human rights standards. You will be aware of a number of other issues. They include the prominence of sections on sexual offences and the need to ensure patient consent. There was support for these sections being removed from the guidance and termination of pregnancy, and on the grounds that the reporting of sexual offences is principally a matter for safeguarding guidance, and the principle of consent is integral to the provision of health and care, and is covered in guidance on the subject. We are minded to remove these sections and refer to specific guidance on these matters, perhaps in either a footnote or an annex to the guidance. That concludes my presentation to committee. As I said at the beginning, despite the criticism the draft guidance received, there was a genuine attempt to listen to the broad range of divergent views on this very difficult subject. The views raised in the consultation have been extremely helpful for the department, and I would like to thank anybody who took the time to formally respond. We're happy to have the opportunity to discuss this matter with the committee, and we welcome your questions. And this time I'm glad to say that we have medical and midwifery colleagues with us who will be able to address any clinical issues that may arise as we discuss the consultation responses. Thank you very much.
Thank you for that. Firstly, I suppose, just in terms of the reference in the response from the department on the wording of the law and the fact that it's 160 years old, would suggest, and I think it's actually in paragraph 6, the wording of the 160-year-old Act means that health professionals might be criminalised for managing a complex issue. It would seem to many, I suppose, that a law that is 160 years old will be open to interpretation. And I'm taking on board your points around the legislation being outside of the remit of the guidelines. But on the issue of fetal abnormality, at one stage the Minister had suggested that consideration of the matter may actually be within the current legislation. And it would seem to many, I suppose, that forcing a woman to continue with an unviable pregnancy into full term and labour that's not her wish could actually result in psychological distress or indeed damage. It isn't in the interest of anyone, and would suggest, therefore, and I'm looking for your view specifically on this, that it would fall, those circumstances would fall into a category of managing a complex issue. I noted that you said very clearly throughout the presentation that this is not about the legislation, that the law has been looked at somewhere else, and that you will update, your words were you will update the guidance. Will the Minister or the Department be considering the issue of fetal abnormality any further and potentially looking at ways in which the guidelines could maybe not be definitive, but could list possible scenarios where the issue of fetal abnormality would or should or need to be considered, or is it simply ruled out?
Well, the Minister took legal advice. Given the level of interest that was expressed in the issue and the very human stories that emerged late last year, the Minister did take legal advice, and the purpose of him seeking legal advice was to establish whether or not the guidance could deal with the subject of lethal fetal abnormality. And the legal advice came back very clearly that to deal with it, it required a change to the law, and that began a process of engagement with the Justice Minister. We now know that the Justice Minister is intending to pursue a potential change to the law by way of consultation. I think we're very clear in the guidance that there is a risk.
I think just to say, you raised the issue about lethal fetal abnormality and the potential impact that might have on some women on their mental health. And certainly the legal advice is clear that, where it is a diagnosis, if you like, of a baby or a fetus having a lethal abnormality, and that has an impact on the woman's health that is mental health that is likely to be long-term or permanent, that would fit within the legal framework that we have currently in Northern Ireland. It's where the continuation of the pregnancy is not going to endanger the woman's life or have a significant long-term impact on her physical or mental health, that in those cases it is outside of the law in Northern Ireland, or not lawful to terminate in those situations. But
do not envisage a responsibility or a requirement in terms of the guidance to reflect scenarios, that given that we are dealing with, as has been said, a complex issue, that the guidelines in terms of clarity should actually consider listing or outlining scenarios?
I think the guidelines has to or we have to provide guidance within the current law as it is, and the law as it is allows a termination where, if the woman's life is in danger or continuing the pregnancy is likely to have a significant and long-term impact on her physical or mental health. And any woman that meets, if you like, those conditions, it would be legal to terminate the pregnancy, and meets those conditions for whatever reason. It's the situation where the woman is very clear that she knows she has a fetus that has a lethal abnormality. She is clear that, well, she wants to terminate the pregnancy for that reason, but that there is no other overriding issues there that would have a significant and long-term impact. It's those cases that are out with the law. I think certainly we can look at making some reference to that, but as Eilish has said, I mean, the Justice Minister has indicated that he is, I think, going to bring a paper to the Executive around lethal fetal abnormality, and that would be in this situation where the lethal fetal abnormality or continuation of the pregnancy would not have any significant impact on the woman's health.
Yeah, no, I absolutely accept that in terms of the law and the current situation in relation to the law. I'm trying to ascertain what the Department's requirements would be in relation to ensuring that this guidelines and guidance is absolutely clear and with absolute clarity. And therefore, I think that if we have acknowledged that we're dealing with a very complex issue, that there is room to list and be very clear on what specific scenarios may be. And that will include lethal fetal abnormality.
Now, I do think that the guidance, I mean, as Margaret has said, I mean, I think what we need to avoid is that medical professions don't arrive at the position that if it's a case of lethal fetal abnormality, that there's absolutely nothing that they can do in Northern Ireland, that we need to await the outcome of what the Justice Minister is actually doing. You know, if it can be shown and demonstrated that there is a longer-term impact on the woman's mental health, then I think we need to address that and make that clear in the guidance, if that's what you're
so what I'm picking up from that is that there will be consideration or further consideration given to this issue in relation to the remit that the Department have on the guidelines.
I think given the spotlight that has been cast upon this particular subject, I think there is an absolute onus on us to provide that clarity. Yes, I agree with you. Okay.
The other issue to raise was the issue around the language of the guidance, and you know, we had noted in our session with yourselves, I think in October, that the language was described as being aggressive, it was patronising, and it was unhelpful. I mean, that was very clear from a number of respondents and medical professions as well. And you did note in the evidence in October that the Chief Medical Officer and the Chief Nursing Officer didn't sign off or even see the guidance. Can you confirm that that is the case?
I don't think that we said that the Chief Medical Officer or the Chief Nursing Officer didn't sign off on the guidance. I think what I said the last time around was that both as members of the working group established to draft the guidance certainly would have had very strong input.
Sorry, my notes from, and we can check it, back in Hansard was that the Chief Medical Officer and Chief Nursing Officer did not proof the document.
I think that's how the question was phrased. Did they proof the document?
But did they or did they not?
I don't think it's for the Chief Medical Officer or the Chief Nursing Officer to proof a document. I think they need to provide their medical their medical advice.
If you know, we're dealing with guidelines that are to assist clinicians and the medical profession. Is it not irregular that you're saying they wouldn't proof?
But maybe it's my understanding of the word proofing in departmental terms. Certainly the Chief Medical Officer and the Chief Nursing Officer would have had huge input to the development of the guidance. On the subject of tone, It certainly, and I think I made the point the last time around, that it was never our intention to be threatening in any way, but perception is everything, and if it was construed that the language used in the guidance was threatening, certainly in a revision of the guidance we will seek to avoid that as much as possible.
Yeah, I'm going to labour this point a bit.
Okay.
I mean, it's not a debate around what is proven. I think we all know what is proven, but the issue here is, did they sign off on it? And I'm not getting an answer.
I think it's fair to say that they will have signed off on it up until the point where they provided their input. Absolutely, they will have signed off on it. There may have been a final proofing exercise undertaken by policy officials, for example, to make certain that absolutely everything was in order, format-wise and any other way. But I think it's fair to say that the Chief Medical Officer and the Chief Nursing Officer would have signed off on the document up until the point where they had provided input to it.
Well, can we have that clarified back to the committee?
Okay.
Yeah,
absolutely.
I think Roy wants in on this
Yeah,
point.
just on this point, in the RCN's response, they've highlighted that in terms of patient confidentiality, were the guidance to be followed, I'll just read a section here. They would commit a flagrant breach of the fundamental principle of patient confidentiality as set out in the code published by the statutory regulatory body, the Nursing and Midwifery Council, and which would lead to nurses' removal from the register. So my question to the Chief Nursing Officer, were you aware of the wording in the document which would have caused a nurse to have breached their code of practice and they would be removed from the register?
I mean, all nurses are governed by the NMC Code of Conduct, which requires them to treat patient confidentiality as an absolute. So, I mean, that's what we would expect practitioners to do.
Were you aware of the wording in the consultation, in the document went for consultation, that would have breached the code of practice and caused a nurse to be removed from the register? And if so, did you make the officials aware of it?
I'm not understanding your.
I'm trying to get to the bottom of how could draft wording go out which would cause a nurse to be removed from the professional register if they followed the draft guidance. Surely that's a very basic feeling in the draft guidance that went out.
I just want to clarify, you're not the Chief
I'm not the
Nursing
Chief
Officer. Nursing
That's just
Officer.
changed dramatically.
But just for clarification, but go ahead if you want to.
I'm not sure the context of that. I would need to look at the RCN response to get the context of that.
Sorry, the nursing officer. The nursing officer, is that
Yeah,
correct? Yes.
yeah. And in which statement they actually said that.
But I think that the point being made in the guidance was, a failure to comply with a code of conduct. I mean, it's a statement of fact. A failure to comply with a code of conduct could lead to somebody being removed from a professional register, subject to it being considered by the relevant committee. I mean, I think that is a statement of fact.
I think within the NHS Code of Confidentiality, there's always the conflict of addressing patient confidentiality and what needs to be disclosed in order to in the public interest. And I think this is the whole debate and issue around when things are not lawful, or whenever there is proof that there is something that has occurred that is not lawful.
I just don't understand how that would have got into the draft. Had the medical officials signed it off until it went into the Minister's office and then it changed, did that happen? Ms McDaniel.
I can't say with absolute certainty what happened, because I took up post a very short time ago, so I wasn't involved in the drafting of the guidance in any way. I had become involved at the point post-consultation and responses have come into the department. It's now my responsibility to produce a set of revised guidance, taking account of what came out of public consultation. So in direct response to your question, I can't answer it with any degree of veracity at all. But if it's, again, I mean, if it's something that you want us to come back to you on, I'm very happy to do that.
Can you assure us that next guidance will meet the basic code of conducts of nurses and doctors?
And we absolutely, I mean, that is a must. I mean, the guidance, I think, it cannot run contrary to established codes of conduct for medical and professionals at all.
But can I just say that I find it very irregular that, irrespective of people's positions, times and post, that we can't clarify the sign-off process from, for guidelines which were so critically important and which were so, I suppose, heavily criticised by the medical profession, that we can't clarify that. And now, we're hearing that even in terms of the RCN response, that the nursing officer here has indicated that she's not aware of it or hasn't read it.
Well, there is a contradiction between, in several areas. I mean, it would include sort of gunshot wounds and knife wounds, between the obligation to report a crime and the obligation to treat a patient in confidentiality. It's not just this area. They do exist uncomfortably in the guidance. It's not a mistake. The codes of practice are quite clear that you must respect the confidentiality. And the guidance in the GMC more or less says that you have to make a judgment on the public interest in whether it's in the interest of the general public to reveal whether a crime is taking place or to respect the confidentiality.
Sorry, Alistair, sorry. My point is, in relation to Roy's point, that the response was given, I'm not aware of that. Or, I find that irregular. I find it irregular that an RCN response hasn't been examined in more detail.
I think I need to clarify that I am aware of the code and I am aware of the responsibility on nurses to protect confidentiality. But also within that, I'm also aware that within the code, nurses have to work within the law. And as Alistair has said, that is the section that this relates to is whenever there is that difficulty of whether they are aware of a situation where there has been something on.
Okay, sorry, can I just be very direct? Have you read the RCN response?
Yes, I have.
You have, okay. Okay, in relation to the part of the response document that we received, talked about medical professions suggesting that the draft introduced a level of doubt rather than clarity. That, in my view, is quite a damning indictment of the fact that the whole purpose, as I stated earlier, of the guidance was to provide that clarity for clinicians. So, having accepted that, can I ask, does the Minister or the Department accept that the document needs a fundamental rethink?
If it is not providing the clarity that is intended to provide, absolutely, we need to look at the guidance again, and that's exactly what we're doing at the minute. And I've given you some idea about how we intend to respond to some of the issues that were actually raised. I mean, I'll say it again, we want to provide clarity. If we haven't provided clarity, then that suggests to me that a revision is absolutely needed. Whether or not it's a fundamental rewrite remains to be seen. I don't actually think that it requires a fundamental rewrite, but it certainly needs revision.
Well, can I ask finally, before I move on, because there's a number of members who obviously have indicated, can you maybe explain today why the earlier drafts of 2009-10 or thereabouts, which were subject to scrutiny by the courts as well, were not just simply amended in the light of that scrutiny and recommended? There was 2 fairly minor amendments proposed. Why those guidelines were not adopted and used?
Can you comment on
Yeah, I mean, we had a new minister, and the minister came in with his own views, and he let the department know his views, and the department changed the document.
The minister changed. Okay, thank you for that. I have Jim.
Right. Ms McGowan, can I take it that this procedure is simply to interpret the law properly as it stands and does not in any way seek to change the present law in Northern Ireland?
It can't change the current law. It is a matter of interpretation of the law and providing clarity about what the law actually means.
And I should have said before I started questioning, and I'm the Vice Chair of the All-Party Pro-Life Group and have very strong personal feelings about this, just in case folk weren't aware of that. Could I just ask, what is the procedure once you go through this consultation period? What then happens through to the final conclusion?
The revised guidance, it's the Minister's intention to clear the revised guidance through the Executive again. Given the nature of the subject, it is a controversial matter. The fact that we've been before you several times now, I think, indicates that it's a controversial matter. So it will go back to the Executive again for final clearance before it's finally published.
And who has the final say on whether these guidelines are published or not?
It will go to the Executive for approval for publication. So ultimately, it's an Executive decision whether or not to approve.
You know that a previous set of guidelines introduced, I think, by Mr McGimsey, were taken to judicial review by the Society for the Protection of the Unborn Child, and on the basis of the judge's decision to overturn the guidelines was a lack of proper allowance for freedom of conscience by those, including many of my own relatives who are in the health profession, who would never want to be in the position of terminating the life of any child. Do you believe the present guidelines properly reflect that judgment?
Well, it deals with the issue of conscientious objection, acknowledges that there should be an allowance made for those who want to conscientiously object. And there are some peculiarities in Northern Ireland in the sense that most of determinations that take place here will probably happen in a fairly emergency situations. So it may reduce the scope to conscientiously object, and I think that needs to be made clear in the document and will be made clear in a revised document.
And you've led into my next question, because you did allude to this issue. Could it be that someone who's got profound moral, and maybe not religious, but profound moral objections to the termination of life could be forced to terminate that life because of the medical situation in which the mother found herself?
If it was an emergency situation, and Margaret, I'd ask you to come in here.
I would hope that we would never get to that position, but if you've got a mother who, if you like, her life is in immediate danger, and if someone doesn't intervene to save her life there and then, there's the likelihood that she and the fetus will die. Now, I would like to think that if that situation were to present itself, that there would be some other clinician who could, if you like, take over the role of managing the mother. But you could be faced, I think, theoretically, with a situation if there wasn't someone there, and they may well have to intervene.
There have been 6.7 million abortions in the United Kingdom, in Great Britain, since 1967. 162 fell into that category. So the chances of that set of circumstances being encountered in Northern Ireland, I thought, are very slim indeed.
And I think should that happen, I would like to think there would be another health professional in the hospital at that point in time. I'm hoping the scenario that you have painted wouldn't arise, but I think theoretically it is possible.
Well, then I'm slightly dubious as to whether the guidelines do cover every eventuality where someone of a very profound Christian background could technically be placed into a position of doing something that he or she could never in conscience do. But as I say, the chances of it happening, I think, are very slim. Now, you published last week the statistics for abortions in Northern Ireland, and the total was 51, 50 of whom were from Northern Ireland. But what you didn't do, and I think it's important that we know this to see the extent of the problem, is the difference between abortions and evacuations. The situation where I've come across personally in my own family quite recently of a stillborn child who was dead in the womb, and that child, for very obvious reasons, had to be evacuated from the womb. Now that to me is not an abortion. You know, that to me is a medical procedure. What the 51 abortions that we have totaled per trust area, what actually do they constitute? And the reason that this is relevant, of course, is it indicates the law as it presently stands.
Yes, I'm aware of the statistics that were published. I mean, those would be terminations of pregnancy within Northern Ireland that met the current legal framework. They would not include the situations that you've described where someone, if the baby has or the fetus is dead and that it has to be delivered, which would be a stillbirth, or there's other situations where, I mean, we talk about spontaneous miscarriage or spontaneous abortion. Obviously, it doesn't include any of those, so it would be those where there was a medical reason to terminate the pregnancy.
The figures published on the 6th of August 2012 did include those spontaneous abortions and evacuations as part of the overall figure, and there is no breakdown in the figures that you've now given us to indicate how many of those, which a reasonable person would not consider to be abortions, how many of those there were.
I think maybe if I understand you correctly, I think there was a time when the figures that were published were around 80, we thought 80 terminations of pregnancy per year. There was an audit done too, which established that in fact some of the procedures weren't being coded correctly. And there was an audit done of the coding going back, I think, about 4 or 5 years. And the figures then were, if you like, revised, and there was around that sort of 40-ish, early 40s that were true terminations of pregnancy. The other subgroup that would have made up the numbers were, and some of those, were people who may have had a spontaneous a miscarriage or a spontaneous abortion, had gone into hospital for some management, were discharged, readmitted, and because there were some of the products of conception still there. So that was, it's the coding convention that requires it to be coded in that way, and those were ones that were coded as part of medical abortion, but they were separate and different from the terminations of pregnancy. And I mean, that's a sort of UK-wide coding convention that applies across all, if you like, reasons for admission and diagnoses. I'm sure, well, we could ask our information colleagues if they can get that information for
those
you.
Figures are available.
That's helpful and gets around that particular issue. Now, allied to the, combined with the publication of the guidelines was a commitment that there would be an explanation given to the department of the reasons for every one of the abortions carried out within the guidelines. And that obviously, in that case, is the 51 that we're talking about. That hasn't happened, and yet that was promised to be running in tandem with the publication of the guidelines. But what's happened there?
Well, I think one of the things we've said that should happen in tandem with publication of the guidelines, and some of that would come out of, I mean, we would envisage probably a care pathway for women, because each and every case will be individual and assessed on its own merit. And whenever the guidance is published, we would, that would be one of the sort of parts, if you like, of full implementation of it, that there would be collection of more detailed information. Again, that's a change, if you like, in what has been currently in place and has been part of the consultation.
But the guidance has been published. Are you talking about the final version rather than the draft?
Yeah, rather than a consultation. I mean, it would be the final version.
Why was it not possible to publish that information in combination with the draft guidance that's before us?
Well, the draft consultation, that was one of the things it consulted on, was the further or the enhanced data collection around the individual cases of termination of pregnancy.
But how do you as a department know that these 51 terminations were carried out in line with the existing guidance if there's no publication of the information to show why the termination was carried out in the first place?
Well, I think, as we said, every practitioner has to practice within the law. Each individual trust has to ensure that the services that it delivers are within the law, and it is the responsibility of the trusts and the individual health professionals to practice.
But how do you know that the doctor is actually reading the guidelines correctly?
I don't think we can ever. I mean,
He doesn't tell you why he did it. Why? How on earth do you know whether he has interpreted the guidelines correctly? It's a shrouded mystery.
And that's why we're proposing to enhance the system of data.
But in a written
so
question
that we
to
do
the
know.
Minister that I posed in early 2012, we were told that from the next quarter there was going to be a publication of statistics on abortions which would indicate how each abortion tied in with existing guidelines. It didn't happen. It didn't happen. We're still here, 18 months later, it hasn't happened.
The guidelines don't exist at present. I mean, we've issued a draft for consultation, and until we finally publish, the guidance does not exist.
Okay.
Okay, Mickey, next.
Yeah, thanks for the presentation. You've answered some of the questions I was going to ask about the conscientious objection, because I think in the 162 cases Jim has mentioned, it becomes, I suppose, more of a moral dilemma, necessarily in a moral decision, because a choice has to be made. And I think you said that if that situation arises, then somebody has to make a decision if the mother's life is in imminent danger. A couple of other things. In terms of the consultant psychiatrist and the two doctors, it just seems that any doctor, I mean, there's a difference between assessing mental health and actually diagnosing it. So I would imagine, as part of a doctor's training, there would have some training in that area, but not necessarily specialist knowledge. And I'm just wondering, if a doctor isn't sure, presumably then they'll seek further opinion. So it just seems that it may portray more of a lack of trust, in a sense, in the medical profession, because you have all these layers of checking, if you like, checks and balances, and I suppose that may be an issue. Also, some international human rights organisations have expressed some concern, because there are issues where, for instance, somebody becomes pregnant through a criminal act, whether it be rape or incest or whatever, and those are issues that really need to be addressed and possibly haven't been fully addressed in the guidelines. And I think the other point that was already made is that these guidelines are to provide clarity rather than doubt, but they seem to introduce more doubt than clarity for the medical profession. That's my own view. So I'm just wondering if you have any comments on those.
Well, I think you've raised the issue about the role of mental health assessment and the psychiatrist, or whether it should be other doctors and what sort of training they have. And I think you're quite right when you say all doctors, as part of their training, will have training in mental health assessment. And I think if you take, for example, GPs, they will do mental health assessments quite regularly in their practice, and that can be different from managing someone who has a significant mental illness. And I think the same would go for, particularly obstetricians, who, as we know, probably see quite a lot of women with postnatal depression, so there's an element of mental health assessment, etc. there. I think one of the things that the General Medical Council requires is all doctors to work within their competence, and if they feel they haven't the sufficient knowledge and expertise for whatever the clinical issue might be, they should seek help from someone who has expertise in that area. I mean, that goes for all branches of medicine, not just within this particular area. So I think that's, I hope that answers that.
And just maybe on the issue of the criminal aspect.
The law on the criminal aspect is the same as GB. It's still regulated with the 1861 Act. That could be changed if the Minister of Justice was minded to take it forward. The guidance can't really address it, because it is, in itself, it is not a grounds for termination.
Then again, if, for instance, that person was going to suffer psychological trauma, then presumably that would fall in the category of the doctors do the mental health assessment and the diagnosis, if that were to be the case.
That's right. Yeah.
There's a follow-on from that.
Okay, I've nobody.
Sorry, just on that issue, I mean, there's been discussion in the summary of responses on the issue of whether a consultant psychiatrist would be required. Has there been any conclusion from the department as of yet? Have they accepted that general medical view that has come from the responses?
I think we have accepted that we will certainly not make it a requirement.
Yeah, well, certainly I've given it a lot of consideration given the views that have been expressed by consultees.
Thank you.
Okay, I just want to sort of, by way of conclusion, pick up on the point around the comments on the from the international commentary around human rights. I mean, I think collectively, whether it is our remit of the legislation or not, we should have a concern if there is a concern there that these guidelines may not be compliant with international human rights law, particularly as Mickey Brady has outlined, in relation to a criminal offence where a woman undergoes rape or incest. And I think we shouldn't shirk our responsibilities on that. I think by way of conclusion, we certainly want clarification from yourselves on the issue that was raised around the sign-off on the guidelines by the Chief Medical Officer or the Chief Nursing Officer. We would request that clarification in writing from yourselves. I think it would be appropriate, given that the huge enormity and need to get these guidelines right, that the revised guidelines would be brought back to the committee in advance of them be taken to the executive to allow us to fully implement our scrutiny role.
Okay.
And just for clarification, Eilish, before you go, you did say, or maybe I picked you up wrongly, but you indicated that it may be the case that the issue of lethal fatal abnormality may be referred to in the guidelines. Is that my understanding of what you said?
I think given everything that has happened, I think it's essential that it is referred to in the guidelines.
Okay, I appreciate that. Folks, can I thank you for your time and clarification? Thank you. Okay, members, can I move people on to item 5, which is the Assembly Research Briefing on waiting times. There is a briefing paper from the Assembly Research on page 48. I think Janice is here, is she? Yeah. We'll just give Janice a minute to get your breath. Thank you, Janice. You're very welcome. I'm just going to hand over to yourself. You're well aware of the retaining here, so.
Okay, thank you. Firstly, I need to start with a small apology. In preparing this presentation, I noticed an error on page 11 of my paper. I stated that the latest statistics showed that Scotland had missed its 18-week target in September, but that was incorrect. In fact, the target was met, as the figures show. I just said it the wrong way around.
We all spotted that.
Catherine has a corrected version of the paper for publication. Last week, the committee started its waiting times review with a presentation from Professor Charles Normand. So, as well as outlining measures that have been used in the Republic of Ireland to tackle waiting lists, he highlighted some very useful key messages. He highlighted that waiting lists are a complex problem lying between the referral of the patient and the subsequent patient treatment, and that there are no simple answers, but lots of answers that will all go together to provide a solution. He highlighted the intended and some unintended consequences of certain initiatives. For example, consistently providing resources to hospitals for waiting list initiatives can have an unintended consequence of rewarding inefficiency in the system. So, having just highlighted that it's a complex problem with no one simple solution, I would, however, today like to focus on what has been seen as part of the solution in England and Scotland, by taking a closer look at the patient monitoring data and targets those countries are using to monitor and control their waiting lists and times. Great strides have been made in England and Scotland to tackle the waiting times issue. With such a complex issue, it naturally has not all been plain sailing, and lessons continue to be learnt in those jurisdictions. The governments and the NHS in Scotland and England have come and continue to come under significant scrutiny of their management of waiting times by relevant authorities and experts. This scrutiny has flagged up a variety of issues regarding the implementation of their policies and targets, and the briefing paper in your packs today aims to cover a selection of those issues. And this is really in preparation for you meeting some experts from those countries over the next month or so as part of your review. At present in Northern Ireland, we don't have any targets based around the total journey time of a patient from referral to start of treatment. Instead, the targets for elective care in Northern Ireland are currently based around stage of treatment by monitoring separate waits for first outpatient consultation, diagnostic tests, and the period from the decision to treat until treatment starts as an inpatient or day case admission. These waiting times, of course, do not include what you could call the in-between waits. For example, the wait between your first outpatient appointment and maybe a subsequent review appointment, or the wait between the results of your diagnostic test and a decision to treat being taken where you might need another consultation. Then the patient will start their wait for an inpatient or day case admission. Those in-between waits are counted in the English and Scottish 18-week referral to treatment targets. So without an understanding of the total patient journey time in Northern Ireland, there are limitations to how stage of treatment data alone can monitor the system here. The policies in use in England and Scotland have been highlighted to the committee in previous raised briefings, and those policies have been in place for a number of years. So this paper in your pack today does look at a range of issues that have arisen and possible lessons to learn from the outworking of their policies. So first of all, I'm taking a look at England. I'm not going to refer to the paper specifically, I just present a few of the issues. As a reminder, in England, their present targets state 90% of patients who were admitted to hospital and 95% who were not admitted to day case should start their treatment within 18 weeks. Hospitals in England now also have a live target to ensure that 92% of patients who are waiting for treatment should have been waiting no longer than 18 weeks. The latest monthly statistics for England show their targets are presently being met. Some of the issues that have arisen around the use of the 18-week RTT and targets in England, I'll look at a few of those now. First of all, it has been commented that the English 18 weeks policy has been one of the biggest success stories of the NHS in the last decade. The paper I've given you details a list of 6 principles that were proposed by experts in the field to improve and sustain the times in England. 3 of these principles would seem to be particularly pertinent for Northern Ireland. The requirement to embed a cultural change so that short waiting times become second nature. The fact that stage of treatment monitoring, as is currently done here, has been highlighted as being no substitute for a management based on the referral to treatment pathway. The need for full GP engagement, as GPs actually hold many of the key levers for achieving the 18-week RTT in England and Scotland. Let's have a look at transformation. Transformation was the key message from the implementation director at the time when the English 18-week RTT programme started a decade ago. It was made clear that 18 weeks was not just another waiting times initiative, but required a complete transformation in the way the NHS worked. And the briefing paper highlights some particular hospital case studies of how such transformation was carried out in practice in the Royal Bournemouth and Christchurch Hospital Foundation Trust and in the Wrightington Hospital in Lancashire. Both of those are examples around orthopaedic units and hospitals. The role of central performance management. One of the innovations of the English policy was the introduction of very strong managerial incentives, and I have mentioned those to the committee before. The Labour Prime Minister's delivery unit was relentless in reinforcing the targets, but there were rewards for good performing trusts with increased organisational autonomy for such trusts. The current coalition government has moved away from such heavy central management. However, it did introduce a new top-down target in 2011 to tackle the hidden waiters. That is the live target I mentioned earlier. A very recent Audit Office report in England has confirmed that, with few exceptions, the waiting time standards in England have been met nationally, although the picture varies between trusts. But the recent strengthening of the standards, with the target in 2011 to tackle the hidden waiters, has had a significant effect on reducing those people waiting a long time for treatment. The recent Audit Office report actually also highlighted the need for continued improvements in England in data collection and performance management, as the information recorded by trusts is not always as reliable as it should be and masks a great deal of variability in actual waiting times. And this, of course, can hinder the identification and management of poor performance. So, as I stated earlier, although they're quite far down the line in resolving their problems, there's still lessons to learn themselves and lessons that we can learn from them. Effect of other reforms. The use of targets in England has been augmented with other reforms to address the supply side of treatment. For example, enhanced levels of patient choice, increased competition and diversity in the market. It is likely these reforms have also contributed to the reduction in waiting times. Taking a quick look at Scotland. In Scotland, the current standards state that 90% of patients should wait no longer than 18 weeks from referral to their treatment starting, and no patient should wait more than 12 weeks for their first outpatient appointment. Recent statistics show that the 18-week RTT was met, but their outpatient target was slightly missed. Those were at the end of September there in 2013. The Scottish NHS boards are also working to deliver what's called a 12-week treatment time guarantee, which has mean once a patient has been diagnosed as requiring treatment, the treatment must start within 12 weeks of having been agreed with the health board. One of the key issues to emerge in Scotland in recent years through their implementation of their 18 weeks RTT was that one trust, NHS Lothian, had actually applied false periods of patient unavailability to appear to meet their waiting time targets. The time that patients are unavailable for certain reasons can pause the waiting time clock, both in England and Scotland. So an investigation did reveal problems in that trust, such as a culture of managers putting excessive pressure on staff to find ways around the system to meet the targets, rather than actually resolving delays in the patient journey. Audit Scotland undertook an investigation to see if such issues were widespread, and although they didn't find any evidence of widespread deliberate manipulation, they did find that during the period of their investigation there generally hadn't been enough scrutiny of the increasing number of patients being recorded as unavailable, as such scrutiny could have identified the pressures that were building up in their system. I mean, when I read that, I couldn't help thinking of perhaps parallels to the committee's recent work on the use of codes around cancelled clinics. Ultimately, the use of codes is widespread in data collection in the NHS, and if those codes, it's the use of those codes with total accuracy that also leads to whether the data is completely accurate or not. Analysis of the current targets in Scotland. One commentator has recently highlighted that their outpatient waits have been increasing rapidly recently. So obviously the Scottish NHS will be keeping a close eye on the build-up of their outpatients, because that does have the potential to overwhelm their other waiting time targets. Because if a lot of their patients are not being seen within the 12 weeks, that only leaves, obviously, 6 weeks to meet the 18-week RTT. So England and Scotland have made major progress in tackling their waiting times issue through a combination, as I've raised, of transformation in patient pathways, significant changes in the collection and definition of waiting times, changes to how waiting lists are clinically and administratively managed, and their centrally monitored targets, backed up in some cases with sanctions and rewards. Over the coming weeks, the committee will hear from experts in the field from England and Scotland, and they will be able to shed further light on the experiences here. I'm happy to now take questions and discuss these issues with you in the meantime.
Okay, thank you again, Janice. Obviously, this is an evolving process for the committee, and as ever, your information is very valuable. I'm probably interested in the information from last week that we had from Professor Normand was very clear that there's no quick fix to this issue, that I suppose targeting money to certain aspects of the problem won't solve it, and in some ways, in his view, you could be potentially rewarding bad practice And it seems to be that the issue remains around looking at the complete patient journey time, which we still don't do. The Scotland do that. Was that in place?
Yes.
That it wasn't just a part of the patient journey; it was the entirety. Okay, and I know you noted that.
Sorry, can I just clarify
Yeah, sure.
that? Yes, the full patient journey is mentioned. Scotland also has a target for part of the patient journey. I mean, obviously, if they're measuring the full patient journey, they also know the data at each stage.
Okay. And then you referred to the central performance management. And again, one of the issues for ourselves seems to be about collection of data and enforcement. And then there was a shift away from the central performance management process. So what enforcement processes worked better in either the English or Scotland model? Because, you know, I know that some of the measures were seen as being very punitive. But what enforcement was
Well, England
better?
started its process a number of years ahead of Scotland, so it perhaps isn't strictly fair to compare them directly. Again, in the English lesson, it seems to have been a combination of factors. You know, the data collection, the heavy top-down management certainly put very, very heavy political will behind the process. They also looked, obviously, at a wider range of issues in terms of the supply of treatments. So I think, I mean, you've hit the nail on the head at the start. It's no one answer. However, to bring it back to the data, if you don't have a clear picture in terms of the baseline of your data and how long patients are actually waiting to be treated, it's a bit hard to see how you can hope to solve the problem in its entirety. Just give you an example. It's hypothetical, but if we're measuring our waits for a first outpatient treatment, and there's then missing periods of waiting that we're not measuring, you could be solving one part of the journey, but if there are parts that aren't actually being measured, the time that it takes to be treated might not, you know, the whole total time it takes to be treated and leave the system will not be known.
Okay. I don't have any other members on the kitten, so Janice, can I thank you for that, again, useful insight. We'll reflect on that as this process evolves. So thank you very much for your effort and time today. Can I move members on then to item 6, which is the review of transforming your care and older people. Members will be aware that the committee has agreed this in terms of our forward work plan and agreed it as one of our strategic priorities, the impact of transforming your care in relation to older people. Can I refer members to a memo from the committee clerk providing the terms of reference and a work plan for the review at page 71. And I'm going to ask the clerk to brief the committee on the terms of reference.
Okay, thank you, Chair. As members are aware, the committee has selected the issue of TYC and its impact on older people as one of its strategic priorities. This session, looking at the TYC Strategic Implementation Plan, one of the key commitments in relation to older people states to support older people and those living with long-term conditions to maintain their own independence and manage the function of daily living in their own home or assisted housing, as opposed to an acute setting or long-term care. It then goes on to say that community-based alternatives to residential care are increasing all the time, and there is a need to ensure that the availability and functioning of these is more widely known so that people can see the different styles of independent living that it is now possible to offer to older people, where the traditional response would have been to offer a residential placement. Due to the improved availability of these types of community-based alternatives, it is expected that the demand for statutory residential homes will decline further. So, as the Department itself acknowledges, in that quote, there isn't a lot of information in the public awareness about the availability of assisted housing options, and this is an area which the committee could explore and probe further, particularly given that the department seems to be placing a lot of emphasis on it and suggesting that the development of assisted living will be a way of reducing the demand for residential home placements. So potential areas of committee investigation, the committee could begin by gathering some baseline information on assisted housing options. So, I mean, to start with, the issues are how is assisted living, or sometimes called supported living, how is that defined, what are the different models available to older people, what facilities are currently available in Northern Ireland across the various trusts, who are the providers, are they statutory, private, voluntary, how much does it cost the client who pays for it, does the department contribute, how are people, or do people have to be assessed before they can access assisted living, or do they self-refer, are there any waiting lists, how do people become aware that there is an option of assisted living, and then looking at the role of the Department for Social Development in that. So once the committee had gathered a bit more background on the issue, it could then start looking at a little bit more closely what is provided for each trust, by each trust. Looking again at the TYC, the implementation plan, there is a section where each trust sets out how it's going to implement the proposals around older people over a 3-year period. And it is interesting that each trust seems to be taking a slightly different approach. And in relation to assisted housing options, some trusts make mention of developing supported housing options in year 1. Others are talking about it in year 2 or year 3, and one trust has no mention of assisted housing. So it would be interesting to maybe compare what is provided by each of the different trusts. And then, of course, the committee could look a bit further afield and look at what models of supported housing are provided in other countries and regions, examples of best practice, both in terms of the options of housing itself, and also in terms of how you go about promoting assisted housing as an option to the public, and or how you make people aware of it. The terms of reference are included in the paper. Number 1, consider the structure and availability of supported living options for older people in Northern Ireland. 2, assess the capacity of supported living options to meet the policy objective of TYC in terms of reducing the need for residential home places. And 3, to identify examples of best practice in relation to supported living options in other countries and regions which could be applied in Northern Ireland. In terms of taking the work forward, there would be a number of witnesses the committee would wish to hear from, the department, and probably also DSD to understand their role in terms of the statutory provision, the 5 trusts, the older persons commissioner, representatives from other older persons, community, voluntary, charity sectors, and there would also be the opportunity then for the committee to go out and visit some of the different schemes that are available, to be able to compare and contrast them. And the timetable would be to begin work as soon as the terms of reference are approved, and to finish this piece of work before the summer recess.
Okay, thank you, Catherine, for that. Comments, Maggie?
Yeah, just, I mean, the terms of reference are very good, I think, but the difficulty is the responsibility for supported housing is DSD's, or providing supported housing. The Minister, I think, in June got up and made a statement to the Assembly that he failed to meet his targets for building supported housing. The DSD committee, which I also sit on, we've gone out to assisted accommodation, and there's some excellent stuff. I think, Pam, you were on that committee. And there's some very good examples, but the difficulty is there's not enough. I mean, you have Fold, Housing Association provides very, very good cases accommodation. In terms of examples of good practice, Scandinavia probably provides the best examples of good practice for older people. You can just visualise Jim in the cold northern hemisphere going around checking that out. I mean, you've been to Cuba, you may as well go to
Jim and I have already discussed this.
Great. I'm sure you've a fur hat in the cupboard somewhere. But no, that seems to be because in countries like Finland, there's a whole holistic effort made in terms of families, in terms of the statutories and all of that. For instance, people in Scandinavia benefits, when you reach pension age, your benefits are paid automatically. You have to go through a whole rigmarole of actually finding out what you're entitled to and when you might get it. There are all sorts of issues around that. So just one suggestion. But I think the support housing, because DSD has already handed back in the region of 52 million they didn't spend. That was the housing executive for housing. So if you have £52 million to hand back, you could build a lot of social housing and indeed supported housing with that kind of money. So those are all issues I think need to be addressed, because there's very many overarching issues with DSD and health, and when you sit in the two committees, it's fairly obvious. And we have the two ministers are from the same party, so you would expect a reasonably good interaction.
One big happy family.
Obviously, we know that.
Right, so
Find that out recently.
I think it's been a very good direction set for the investigation to follow. The one thing I'd like to add is in following supportive housing, I think it's important to know if any supportive housing has been earmarked for particular groups, because various groups are for young people with learning difficulties, for instance. And it would be inappropriate perhaps to have someone with learning difficulty moving into another area where it was a group of older people, and to agree vice versa. So if numbers are coming through, we need to know if they have been earmarked or restricted to any particular group, because that will obviously limit the numbers that would be available to older people.
Okay.
But just saying, following Ray's point, that is a good point, because the lack of praxis, for instance, in Uri, have accommodation for people with particular problems, not necessarily all older people. And you're right, because you need that balance and that kind of...
Okay, Gordon.
Thanks, Chair, and I think we'd welcome the work that has been done on this. On the talking to the various departments, I think obviously bringing in the health professionals, OTs, I think their opinions would be valued, certainly us as local representatives. But, we're in constant contact with OTs, and it's always an issue trying to get them to make assessments when required, so I think that's an important area. The other thing is a federation of housing associations probably would give evidence to us about their experiences and their engagement with housing associations, who really are the lead agency now on new builds. So all of those, I think, issues could be explored, but I do think it's a good bit of work, and it's important, I suppose, we don't do the work of DSD. I know they're a fine committee, and there's a fine minister in place,
very much,
with fine representatives on it.
Take that as a compliment.
I think we need to make sure there's no duplication as such, but there are issues there well worth exploring.
Okay, thank you for that. I mean, I think it is important that we're not duplicating, and I think that's one of the reasons why we had identified that when we look at older people, there's already a consultation taking place in terms of residential care. We don't need to do that. We obviously need to monitor and track the outcomes from that, but there was a commitment in transforming your care in terms of assisted housing or supported living. So what does that mean? So I think that we're correct to focus on that, and I think even within the terms of reference, the second one is about assessing the capacity of supported living options, and that brings up all sorts of issues around care, about, if it is supported housing, the issue of domiciliary care, for example. So it brings up all sorts of issues there, but I think it's very clear and it's a good piece of work, and if members are content with that as a terms of reference, then we can move to activate that. Okay, thank you. Okay, members, moving on to page 75. which is an SL1, and the next two SL1s are actually about making it unlawful to possess, supply, produce, import or export a range of harmful new drugs in order to protect public health. Item 7 is a proposed statutory rule, which is the misuse of drugs designation amendment order. And I ask our members' consent for the department to proceed with the statutory rule.
Great.
Item 8 is another proposed statutory rule, the misuse of drugs amendment regulations 2014. Again, our members' consent for the department to proceed.
Great.
And item 9, proposed statutory rule on the meat product regulations. And I'm referring members to the SL1 at page 87. The purpose of the statutory rule is to implement EU regulation number 1169/2011 on the provision of food information to consumers. So again, I'm asking our members' consent for the Food Standards Agency to proceed with the statutory rule.
Great.
10 is a statutory rule, the General Dental Services Amendment Regulations. Referring members to page 82. And the department considered and approved the SL1 for this rule at its meeting on the 11th of December 2013. So our members content with the statutory rule.
Great.
Okay. So therefore, I'm putting the question: the Committee for Health, Social Services and Public Safety has considered the General Dental Services Amendment Regulations 2014 and has no objection to the rule.
Great.
Thank you. Item 11, members, is the Forward Work Programme. I'm asking members to note that, which is on page 102. Under Matters Arising, item 12.1 on page 105 is a response from the Minister about the provision of health services to failed asylum seekers. The Department have agreed to engage with the Law Centre and other stakeholders on this matter. So are members content to note this for the meantime?
Great.
And item 12.2 on page 103 is correspondence from the Law Centre on the same matter, so I'm asking members content to note.
Great.
Under correspondence, I'm asking members to note 13.1 on page 108. 13.2 on page 130 is a written statement from the Minister in relation to procurement issues in the Northern Trust. An investigation was carried out by BSO, which concluded that work totalling 5.7 million over a period of 14 years was not subject to proper financial controls. However, there's no clear evidence in the statement, as indicated, of fraudulent activity. At the end of the statement, however, the Minister states that there will be an independent review which will consider if any further actions are needed. I'm suggesting, members, that we write to the Department to ascertain who would actually carry out that review and what the terms of reference and timescale would be for that, if members are in agreement.
Great.
Thank you. Asking members to note items 13.3 and 13.4 on pages 132 and 142. Page 144 is correspondence from Una Crudden about ovarian cancer. Members will recall that the committee held a debate on this issue last March. We also organised an informal meeting with Ms Crudden and the Minister to discuss these issues. Ms Crudden is seeking an update on what actions are being taken to raise public awareness. The Minister in the Chamber during the week did indicate that the PHA were working up proposals around a campaign, and that there would be a few more months before that was actually implemented. There's certainly concern from Una Crudden and other campaigners that this is almost a year old. I'm suggesting, members, that we schedule an evidence session with the Department and the PHA for an update on what actions they have taken over the last number of months, and I'm suggesting that we write directly to to inform her that we're taking that action.
Could I strongly support, Madam Chair, that proposal? I met Mrs Crudden through the previous, the Chair, Sue Ramsey, a remarkable woman, and I think I am in a position to say this. Mrs. Crudden, as you know, has ovarian cancer, and would be truthful to say that time is short, and she is extremely keen that this issue is dealt with before her health deteriorates to a point where she can no longer carry her campaign. So, in supporting what you're doing and agreeing with it, could we have that as quickly as possible?
Absolutely, absolutely. Thank you. Maggie, sorry.
Echo what Jim's saying, because I've met Mrs. Crudden, as other members of the committee have. She's put a lot of time and great effort into promoting this campaign, and it would be an injustice if it wasn't done as quickly as possible. And I think the urgency needs to be stressed, and I think Jim's right, the sooner the better, because she has put so much work into it, and the woman is she could do her own election.
Yeah, I'm totally agreeing with what's been said. I met Una this week. She was in the building this week, and there was an answer from the minister. And I'm not so sure whether she was completely satisfied, because on speaking to Una, her concern was that the awareness was being lumped into others. She, and I think we should agree, that her specific one must be done quickly and on its own if possible, so that the awareness is got out to the right people now.
Thank you. No, I mean, she did correspond with me directly after that, and she wasn't satisfied, as you can imagine, given the commitment around the debate. She was not satisfied on the length of time that it's taken, and also not satisfied that it wasn't even perceived to be a standalone campaign.
Correct.
And given the misdiagnosis of so many women, the need for it to be a standalone campaign. So yes, take on board that. That certainly would be my view, that we activate that as soon as practically possible. Thank you, members, for that. Can I refer you to page 145, which is a letter about a personal case, and our members' content as in process that we refer the correspondent to constituency representatives for support.
Yeah, just on that, do we actually send these to the constituency offices? Is that the normal practice? How do we action them?
Catherine.
Chair, we write back to the person who's written in and provide them with the details, the contact details of their 6 MLAs, and suggest if they may wish to contact one of the MLAs for further support and assistance.
Right, okay. Thank you.
Gordon. Okay, members are content then to refer that to constituency representatives. Item 13.7 on page 154 is an invitation to a conference organised by the PHA on learning disability. It covers a lot of issues covered in the piece of work which the committee have just finished, and a member of staff will attend on behalf of the committee, but if there's any members who want to attend, please let the committee office know. Item 14 is any other business. Do members have any other business?
Chair, yes, I think it would be remiss of the committee meeting so soon after a number of debates, and particularly yesterday's debate around crisis conditions and a number of our hospitals, particularly in relation to emergency. But I think that threw up, if you like, a whole range of issues around accountability, decision making, provision, etc., etc., etc. The fact that all parties agreed, or most parties agreed and voted in good numbers in terms of backing that motion, and even in further debate last night around Lagan Valley, we had a reflection from DUP members about accountability issues as well. I would propose, Chair, that these are provoking questions for the committee, which only the Minister can answer. And I would recommend that the committee write to the Minister and ask him to come to the committee as soon as possible to discuss these in a way that targets them more. I mean, a debate is good. It throws up the issue. The parties agree on it. It underscores the import. But I think interrogating the issues, particularly given concerns from patients, unions, staff, and some of the comments from organisations like the RCN, that some of these issues are of such a crisis that they could make the service unsustainable. I think those are issues, given that this committee's scrutiny role that we cannot ignore, and that there's only one person that can really reflect on them in an adequate way, and that's the Minister himself.
Okay, any views, Roy?
Perhaps another issue which might well be dealt with possibly at the same time. We were given a briefing on the January monitoring round, bid for 65 million, 67 million. We were told, if my memory's right, there was 43 million of inescapables. We're also advised all the trusts are operating in a deficit. So there's 43 million inescapables, everybody's in a deficit, and the Minister gets 30 million. So how are the books going to be balanced between now and the end of the year? How are the inescapables going to be met? And how is the service going to be provided? What choices is the Minister going to make with this 30 million?
Well, what traditionally happens is that Julie Thompson comes before the committee later on in the financial year and tells us how she's escaped once again. She always seems to do it. I think it's no harm to ask the department where we now stand budget-wise, because she always comes in November and tells us we're 40 million overdrawn, and then she tells us in February that it's all going to be right again. And I hope that's the case this year. But I think we need to just check up to see where we stand.
Well, I think we should seek that update, as because we are moving towards the end of the financial year, and I think, given the monitoring round issues as well, that we seek clarification from the department as to where the budgetary issues are. Going back to Fergal's point, I think it's a valid point. It's a really critical point for all of us, and perhaps, you know, in asking the Minister to come in, we ask him the commitment that he gave in and around the actions coming from the College of Emergency Medicine report, where he has suggested that there is a developing action plan around those proposals that we seek, recognising that that's Belfast Trust and the issue it can be wider and is wider, but we ask for an update at that meeting for him to provide us with an update in relation to that action plan. So are members comfortable that we do that? Okay, thank you for that. Date and time and place of next meeting is Wednesday the 5th of February, starting at 2 p.m. in the Senate chamber. Thank you.
Thank you.
What are you worried about?